introduction, Andy. John Alban here to tell you about estate planning, and I told you what I would focus on today is what you do after you've signed your estate plan. So estate planning is a process, and I start by meeting with you, and you tell me what you would like to plan for your estate, and then we do the documents for you, which include your will, your revocable living trust, powers of attorney, healthcare directive, and you sign those documents. And some people sign documents and just think they're done. You know, the plan's taken care of. But today I want to go over three things that I go over with my clients after you've signed, and I give them an instruction letter. And these three things, the letters are T, L, and A. So T is for title, L is for location, and A is for access. So that's three things you really need to focus on. For those of you who have signed your trust and just, buried it somewhere, that's not the right thing to do. So take notes today if this applies to you. First thing, title. After you sign your trust, your estate planning attorney should tell you what assets need to be titled in the trust. And not all of your assets should be titled in the trust. But specifically, you should go over and determine what ones are supposed to be governed by your trust. The attorney should tell you that. And then there's different ways to transfer your assets to your trust. So after you've signed your trust, if you own real property, you also sign a grant deed, and that gets recorded. So that's one step that you do after you sign your trust. Then most of us have a bank account, and you have to transfer the bank accounts that you want into your trust. So you can see Chris Lynn, at the bank. She can help you open a trust account. I'm sure she'll tell you she's done it before and many times, but that's something you have to focus on, again, after you've signed your trust. The other assets people have, personal property, that's something you have around the house, so that's not something you always change title on. But many people have business interests, many people in this room. Again, that's something you have to transfer to your trust if you want it governed there. And that's where you'd see a business attorney like Mark Holmes or your business partners to make sure that there's the agreement that that's in your trust and that's titled in your trust. Certain assets, like retirement assets, do not get transferred to your trust. Those are assets that are yours for retirement. And they're already in a special agreement and basically a trust that says it's going to be there for your retirement. So you wouldn't transfer those to your revocable living trust. So moving on to the next letter, the L. This is the location of your documents and the location of your assets. So just because you've signed your documents, you want to make sure somebody knows where to locate them when you're not here. So that's where you notify your successor trustees. You've signed your documents, and you're going to locate them somewhere safe. These are documents that you need the originals. So an original will, an original trust. After you're not here, that's the document that's going to govern. We recommend people put them in their safe deposit box. That's kind of the place everyone looks when you're not here for your valuable things. So especially your documents and then some valuable assets. So make sure people know the location of your documents. The other thing is the location of your assets. Tell them where they are, what bank they're at, hopefully with Chris, Union Bank, or hopefully with Ron Budd with financial assets. So make sure someone knows that. Again, the location. And the last letter I said A, access. Whoever you told the location, make sure they can also access your safe deposit box or your documents or whatever assets might be needed at an important point in time. So again, I wanted to focus on those three letters, T, L, and A. The title for your assets, location, your assets and your documents, and then that someone would have access when it's necessary to do so. So I focus on those things after you've signed your estate plan. It's very important to have that extra advice and help afterwards. So now if you've completed all of that, give yourself a pat on the back because you've done a good job. And then there's more to do, right? As I think Val tells us every week, you got to do maintenance. You know, Val tells us that on your car. You know, John Thomas tells us that on your house. You know, you got to repaint every once in a while. Or Terry, you know, keep those pests out, keep your maintenance contracts going. And Jay's not here, but you know, your air conditioner, you got to keep these things maintained. So the same with your estate plan. How often is up to you. Everybody's going to have a different maintenance plan on how often they need to maintain their documents. What's most important is that annually you see the key people that you have to. So one of them would be Mike. You know, you have to see someone for your taxes every year. So he's one of my power partners because he's going to tell you where you are and if there's changes in tax laws that might affect your estate. Another person is Ron Budd. You want to review your assets. You know, Ron will tell you at least once a year, probably more often. See where they are. See, you know, if they're with Ron, you know, going up, you know, that's great. But we might need to do some estate tax planning. Insurance, then, also important. Crystal would tell you, you know, your Medicare, your health insurance. She's someone you should see annually and make sure that's okay. And Eric Evans for property and casualty. Just these type of people that you have to see annually, they're kind of good power partners for me because they can tell you it's time to check up and also do your estate if something significant has happened in your life that you might not think trigger your estate, but it would. So occasionally you'd schedule an appointment with me to maintain. That's a good time to do it is when you have family changes. So a marriage, a divorce, a new baby, a new grandbaby, a death of a loved one. You know, anytime you move, you know, you will probably want to see if you're moving out of state is very important because each state has their own probate laws. If you sell property, again, back to the other letters I told you, the title and the location. You're moving, you got to tell somebody that. It's a good idea also to tell us and update your plan. And then for my finale is, of course, your finale as well. It's good to talk to your funeral director, Kathy. Make those plans in advance. Make sure somebody knows what you want. And again, your health wishes, funeral, burial arrangements. That's things I can incorporate into your plan. And you should also talk to your health agent about that. Okay. Okay. So we do have a couple minutes. Sometimes you have questions. If you do, you know, general questions. If you have specific questions, please call me or schedule an appointment. You know, I'm happy to talk to LaTip people when I can. Kathy?
Can you briefly explain a durable power of attorney and is a healthcare directive always automatically understood that it's in there?
Okay. There's two documents that can be durable power of attorneys. One is a durable power of attorney for assets. The word durable means that it's going to continue after you're incapable of making decisions yourself. So when you sign a power of attorney, you're normally giving power to someone to sign your name or make decisions for you. And durable means they can continue to do that if you're incapacitated, if you lost your faculties or your ability to write. Power of attorney for healthcare, a durable power of attorney for healthcare.
You still need two.
You still need two. They're two separate agents. And the healthcare is now called an advanced healthcare directive. And that's the one that gives power over funeral decisions with your body, both while you're hospitalized and after you're no longer here. So that's an important document to have, taking care of your assets and taking care of your body. Okay, Don.
John, I know you're talking about revocable living trust that you can make changes in. Are there any occasions where a person might want an irrevocable trust?
Okay, that's a good question. That's the question. I did generally talk today about the revocable living trust, which would be the most common document because it can serve as a will for you in addition to your will to help avoid probate. The irrevocable trusts are also important documents. They're normally done with people who have assets who are going to be at an estate tax level. So it's other decisions we can help you with when your estate's at that level. Thank you.
Win. I like that.